The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you kindly. Good morning to you all, and welcome to the Massachusetts Appeals Court. My name is Judge Desmond. With me is Judge Sachs and Judge D'Angelo. We have 5 cases scheduled for oral argument today, the first of which is docket 22P0099, Department of Children and Families versus Mother and others. It's my understanding that both the appellant and the appellee will be splitting their time. As to the appellant, it will be 7.5 minutes for each, the father and for the mother. And as for the department and the child, it will be 9 minutes for the department and 6 minutes for the child, as I understand. Is that accurate? So with that, I believe the father is going to do his presentation first. And so, Attorney Haynes, you may begin.
Thank you. Justices, counsel, Rebecca Haynes for the father. Father asks that you reverse the decision of the trial court, finding that he continues to be unfit and terminating his rights. And I argued a couple of different arguments in my brief, but for today, I'm just going to focus on my last argument, the argument about father's due process rights that were violated in this hearing because for 3 days, he was present in person while his attorney was present over Zoom. So the right to parent is a fundamental right, and parents are afforded the right to counsel in proceedings, especially in a proceeding to terminate their parental rights. In this case, father had the right to counsel. However, for 3 days, he really didn't have effective representation from his counsel because his attorney wasn't there with him, and he couldn't talk to his attorney during
Counsel,
Yeah.
didn't the judge at the beginning of one of the Zoom hearings notify the parties that if at any time they needed to speak to their lawyer to let the court know, and they would make arrangements somehow for that to be done?
So I did not see that in the record. Had the judge done that, I think it would have been a different story. I didn't see that in the record. I think that the father was illiterate. Spanish was his first language, and he didn't have a telephone. On the record, in the motion for an in-person trial, his counsel brought up the fact that father didn't have a phone. So even if father could have stopped the proceedings, he didn't have a way to communicate with his attorney. And I don't think the judge on the record said to him, do you have a way to communicate with your attorney? And if you don't, let's figure out a way we can stop the proceeding if you want to stop. So, I mean, I think that safeguards could have been put in place, but I don't think that happened in this case. I think
How many days was the trial?
So the trial itself was 9 days. So this was 3 days.
And which 3 days are you referring to?
So it was the first day. So the first date was the February date that they came back after the pandemic. So they had testified for 3 days and then up to February 2020. And then, so January 2020, there was 1 day, 2 days in February 2020. And then when they came back in February, the first 3 days they were back. So just 2 days in February and 1 day in March, when counsel was only present virtually for father. So the first day back, and then 2 other days.
Counsel was present for the final 3 days of the trial, is that correct?
Correct. But during those 3 days that counsel wasn't present, father testified. He started to testify on one of those days. And in fact, during his testimony, an issue came up about whether the Fifth Amendment right against self-incrimination came up, and the judge asked everybody to leave the courtroom, and he just talked to the attorneys about how he was going to appoint an attorney for the father to go over his Fifth Amendment rights. And when the judge called everybody back to explain that to them, father clearly didn't understand. And on the record, father said, so are you giving me a new attorney? And the judge said, no, I'm appointing an attorney to talk to you about your Fifth Amendment rights. And again, the father didn't appear to understand. And on the record, the mother said, I'll explain it to him. And also on the record, the judge asked father's counsel if she was in communication with her client, and father's counsel said that he wasn't taking her calls. I think that had she been present in person and an issue of the Fifth Amendment came up, they could have gone out of the courtroom and talked. And if she couldn't communicate with him, she would have come back in the courtroom and said, Your Honor, I'm trying to communicate this to my client and he doesn't understand it. But that didn't happen in this case. He didn't have that protection. And I think that the termination of parental rights is a huge, it's huge. Rights to be a parent are like civil rights. And he didn't have protections during these 3 days of the trial. And I do think that that it should be vacated. And so because of that violation. I think another issue is that there was no motion for new trial filed, but I think that the issue was preserved because his attorney clearly objected on the record and said that there was a due process violation. And also, I would say that this is exceptional circumstances. And I think that it's important that the court rules on this so that in the future, counsel and judges will know what is necessary for due process and effective representation, what needs to happen, because I think we're going to have a lot more virtual hearings or partially virtual hearings. And I do think it makes a difference. If this had been all virtual and father was over Zoom, he could have gone to a Zoom breakout room and talked to his attorney, but this wasn't all virtual. And on the record, it was clear that father didn't have a phone, didn't have a way to communicate with his attorney. So another issue
Do you have a transcript site for that? I didn't catch that my first time through.
For what, that he didn't have a phone?
And that he wasn't taking his attorney's calls?
Oh, yes, I do. Find where that. I do. Can I write a letter? And I do have it, but I can't find it right now.
So how can both of those things be true? If he doesn't have a phone, how can he not be taking the calls? Do we know where counsel was calling?
We don't know. Perhaps she was calling the mother's phone. They were together. I don't know. I just know that on the record, the attorney did say he hasn't been taking my calls.
It's transcript 871.
Thank you very much. So, and I'll just briefly, I wanted to talk about another issue that I know child's counsel is going to bring up, and that's the child's position that he wants to be adopted, that he's very bonded with his adopted family, with the pre-adopted family. I just wanted to say that what happened on this case is that the pandemic happened, and father got no more in-person visits with his child for over a year before the trial started. And that's something that DCF had control over, because they started doing visits again in July of 2020.
That's the subject of a motion?
They did not, no, there was no motion. There was no motion filed, but I would say that affected the bond that the child had with his parents. And obviously the department already has an advantage, and then they get to use evidence that they created to further make their case that father's rights should be terminated. And then I rest on my brief. Thank you very much.
Thank you. Any questions from the panel? Hearing none, Attorney Robin.
Thank you, Your Honors. May it please the court, Jeremy Robin, I too am one of the appellants here. And in the interest of the limited time that I have, I would like to just address in some detail one of the issues that's raised in our brief. And that's that the trial judge's excessive and prosecutorial questioning rose to a level that exceeded the normal bounds of where a judge should question a witness. And there are two cases that speak to what the standard here really is in terms of what a judge can do. And judges are given wide latitude. The reality, though, is that a judge sits on a raised platform, wears a robe, and can be an intimidating figure for a litigant. In this case, the mother, who was not highly educated, wasn't highly sophisticated. And Commonwealth of Hassey is the first case that I'd like to address. And Hassey was a case where it was a rape trial and there was a conviction. And the defendant's main witness had a credibility issue. And the trial judge there, instead of just asking questions and clarification, took functionally a role of co-prosecuting counsel, asked a number of sharp questions, sharp leading questions, again, not to get clarification, not to get information, perhaps to embarrass a witness, but to put the primary issue in play, which was the credibility of this witness, same as is the case here. The credibility of the mother was largely in play, comprised a number of the findings from the trial judge. He didn't think she was telling the truth. She was exaggerating, she was being dishonest, etc. And his questioning, the trial judge's questioning here, spoke to that primary issue. So with Hassey, the appeals court reversed the rape conviction on this basis that the leading cross-examination by the trial judge, figure who has to stand in a position of neutrality for obvious reasons, crossed the line and was therefore reversible error. In the other case—
So that was a rape case, and this is a care and protection.
Correct.
And do you think that makes a difference?
I think it does insofar as that was a jury trial, correct? And the judge was not the finder of fact. The judge was the gatekeeper. So in that regard, there is a difference. But in some ways, I think this is worse because, at least in that case where you had a jury, they ultimately had the say. Granted, they were likely influenced by what the judge said and did, but here the judge was the finder of facts. So while different in that regard, I think in some ways it was more glaring in my view. The second case I'd like to address is Norbert, which was parent protection case, termination of parental rights. In that case, the judge asked 1,000 questions. Difference between that case and this case, the majority opinion was, while what this judge did was improper, didn't rise to a level of reversible error. So they didn't upset what the decision was, but there was a very powerful dissent in which the judge determined that the prosecutorial questioning by this trial judge violated a fundamental fairness to the litigant and set up perception to all litigants that the court can't cross, a certain line the court can't cross in compromising what would otherwise have been a fair trial. So,
Counsel, it's clear that the judge did ask some questions in this case. Can you point us to what questions you specifically say went over the line?
yes, and I will do that. My apologies, I don't have the citations right in front of me, but if permitted, writing a letter of some sort, I can get that. But one example I just have in quotes here is the judge saying, quote, to the mother, "You're asking the court to believe that for 3 years you had insurance issues and you couldn't resolve your insurance issue. Is that what you want me to believe?" The tone there, I believe, is derogatory. He knows the answer to that very leading and embarrassing question.
Where's the answer?
Well, I think the answer would be he thinks she's lying. He thinks she's not telling the truth, so he wants to kind of take
He's
it out.
asking her to explain something that seems inexplicable to him. Is that permissible? I mean, and not based on any preconceived notions, but based on what he's seen in the trial so far.
So if he's convinced, I guess I would ask a question as to that question. If he's convinced as to that determination, why are these additional questions needed?
Well, is he convinced, or is he giving her a chance to say, hey, this doesn't really add up for me. Can you explain? How could it be that you let the situation go on for 3 years?
It's possible. I mean, I'm not in his head. I don't know what he was thinking, but based on the findings and based on how he issued so many findings that spoke to her lack of credibility, I mean, that's such a seminal issue in his determinations. I tend to think at that point, he knew the answer in his head and he wanted to kind of shake it out of her and get some sort of a confession or admission. But the other example is a bit of a shorter one where he says, quote, "Your son talks about adoption. What does he mean?" Now, I think in that example, he's again wanting to sort of shake out of her. He says adoption, he doesn't want to be with me, versus the testimony, the essence of the testimony that she previously given, which is, He wants to be with me. I have a loving relationship with him. He's been with me 6 of the first 10 years of his life, etc. I raised him. So I sense a tone of sarcasm and overstepping. But the other point I'd like to make is that in the typical way things play out, judges who ask questions, judges who ask a lot of questions, it's for clarification, and they'll open the door to counsel to ask questions on their questions. It's a common practice. From my read, that didn't happen one time here. I think that's indicative of the mindset of this judge. Before I run out of time, though, I do want to reference that this same judge, the same issue, raised in this court before a different panel about a week ago, and that docket is 2022-P-0090. Same issue, same judge. That's all I have. Thank you.
Any additional questions from the panel? Hearing none, we'll move to the appellees. Is the department going to go first?
Yes, Your Honor.
Okay, Attorney Gao.
May it please the court, Trini Gao on behalf of the Department of Children and Families. I'll just first address mother and father's respective due process claims. As to father's due process claim, and the ineffective assistance of counsel claim, the bottom line is that father did not allege any prejudice that occurred to him due to the delay in trial. And as to his counsel's being present virtually for 3 of the trial dates, once the trial resumed, there was no evidence in the record to show that his counsel was unable to view and hear the witnesses that testified and effectively cross-examine them. In fact, the court took pains to ensure that father's counsel was able to at all times see and hear the witnesses. There were several pauses taken during the course of trial to make changes necessary so that she could. And we know from Vasquez-Diaz and from Guerin that the fact that father and counsel were not in the courtroom together, and that father was not able to pass notes to counsel or immediately communicate with her, that alone is not sufficient to find that that counsel is rendered ineffective. The question is whether counsel is able to, have control over cross-examining witnesses, be able to see and hear them, and she was in this case. And furthermore,
Counsel, what about the fact that, according to opposing counsel, the judge never instructed any of the witnesses or the parties that if they needed to speak to their lawyer to raise their hand or to speak up so he could make arrangements for them to speak? How was, in this case, father supposed to even know he could do that if the judge didn't instruct that?
Well, under Vasquez-Diaz and Guerin, there's no affirmative duty on the court to provide those instructions, although it is, I will admit, looked favorably upon. It is not, the lack of instruction is not sufficient to find counsel to have been rendered ineffective by it. From Vasquez-Diaz and Guerin, we know that without a showing that father and counsel requested some procedure or process be taken so that they can break out and communicate with each other, counsel is still effective in her representation of the parent. So without anything on the record to suggest that they made that request and were denied that by the court, father's claims as to ineffective assistance are meritless.
Well, couldn't that argument flow into the ineffective assistance of counsel argument, that the lawyer was ineffective for not asking the judge to make arrangements to speak to his client?
Well, I don't believe father raises that issue. I believe the ultimate issue is whether counsel was effectively able to cross-examine the witnesses and counsel father through his testimony. And the fact that counsel did not raise the issue on her own request a break or request procedures on her own does not render her ineffective. There's no case law suggesting that would. Turning to mothers.
Before we turn to mom, let me just ask. So these were the 3 middle days of trial, is that correct?
That's correct, Your Honor.
And at any point, once they resumed back fully in person, the final 3 days, did this issue come up?
No, it did not, Your Honor. And turning to mother's claim that the judge acted inappropriately here by asking clarification questions, the bottom line here is that the judge was asking questions to clarify mother's own testimony, inconsistencies in her own testimony as to child's interest in being adopted, which I believe mother points out in her brief, that example. So at page, I'm sorry, if your honors would permit. So at page 531 of the transcript, mother cites judge's question to mother, what did you understand child to mean when he told you several times that he wished to be adopted? After she had answered that she did not understand those statements by him to mean that he wanted to be adopted, that is a clarification question that is well within the bounds of the judge's role as fact finder here, the ultimate fact finder on the issue of whether parental rights should be terminated. He had a paramount decision to make. He needed to be clear in his findings. He needed to make sure that he understood mother and father's testimony, and all of his questions and his conduct during the proceedings reflected that and were consistent with that. And mother's suggestion that there was some bias or some attempt to embarrass her, even if the court credits that, mother cannot cite to any care and protection case in which the reviewing court reversed on the appropriateness of the judge's conduct alone. We know from adoption of Norbert, which mother's counsel brought up, as well as adoption of Seth, that even where the judge where the reviewing court explicitly finds that the trial judge perhaps crossed the line, acted inappropriately, that was not sufficient to reverse the juvenile court's order without a finding that there was some outside bias or prejudice, and not opinions that were derived from the judge's participation in the case. And mother cannot show that there was that here. So again, mother's claims are likewise meritless.
Can I jump in and ask you a question about
Yes,
what nexus did the judge point to, specific nexus between substance abuse by either of the parents and their fitness?
Sure. So there was a nexus here in that mother and father throughout the entirety of the case, from even prior to the department becoming involved, were unable to take care of child. We know that from child having to reside with maternal grandmother, because at the time mother was unhoused. She, at least once had taken.
Let's talk about the couple of years prior to trial, not 2016 when the case started.
Okay, so as to that, Your Honor, child was in the custody of the department already at the time. Mother and father failed to demonstrate sobriety, failed to consistently engage in treatment.
Okay, but the failure to demonstrate sobriety doesn't in and of itself establish a nexus to unfitness. That's what I'm asking about. There's some, at least as to the father, that he didn't use illegal substances since, I think, April or May of 2018. What specific unfitness did that indicate?
That indicates, Your Honor, two things: that father was unwilling to take the steps required to demonstrate his fitness and his likeliness to be fit.
That's not his burden, is it?
His burden is to the department's burden is to show. Your Honor, I see that my time has expired. If I could answer your question.
Continue.
Okay. It is the department's burden to show that father is unfit, father and mother are unfit, and that their unfitness is likely to continue. They did that by showing evidence of father's unwillingness to engage in treatment and failure to demonstrate sobriety. And this court need not wait for irreparable harm or danger to be put on the child before finding that nexus. As I said before, it was clear that child was unable to reside with mother and father due to, in part, their substance abuse. And that alone is sufficient to find that, that alone, even without all of the other considerations underlying unfitness, was sufficient to find a nexus between mother and father's unfitness and their ability to parent child.
So when you're talking about the substance abuse in the final couple of years, are you pointing specifically to marijuana use?
So the marijuana and alcohol use are relevant to father's inability to demonstrate sobriety, but there is additional evidence on the record that father had abused heroin prior to that as well, and had failed to seek treatment for that consistently. And, we have evidence on the record that mother admitted that since returning to Massachusetts, since father had returned to Massachusetts, she and father had been using heroin once to twice a week for about a year. So, that evidence in the record was that's the evidence I'm referencing when I'm referencing father's substance abuse and failure to demonstrate sobriety.
Thank you kindly. Any other questions from the panel? Attorney Gao, thank you very much. I see that's your time. Attorney Nussbaum. You're on mute still.
My apologies. Good morning, Justices. Beth Nussbaum for the appellee child. As a threshold issue, I would like to address something that father's attorney raised with regard to the Fifth Amendment issue. I would like to point out that there was a break in the court dates between the date that the trial judge announced he was going to appoint Fifth Amendment counsel and father's testimony. It occurred on, and if the court would allow me, I'm just looking at the trial transcripts now. It was March 3rd. It was February 18th when the court announced it would appoint Fifth Amendment counsel for father. Hearing recommenced on February 19th. I believe there was a continuance that date. No, there wasn't, but father then testified again, page 904 of the transcript, which was on March 3rd. So there was a significant period of time between those two dates when father's counsel could address the issue with father and explain everything that he needed to understand, as well as his meeting with Fifth Amendment counsel. So there certainly is no prejudice there. Turning to the arguments that I would like to address on behalf of child, mother testified on page 310 of the transcript that she would not agree to an open adoption, even though she knows it is in child's best interests. And even if it were his wish, because it hurts too much, in quotes, she already lost another child and she didn't want to lose this one. That was mother's testimony. Despite the evidence that child raised the issue of adoption numerous times during visits, father simply denied that child ever told parents that he's happy in the pre-adoptive home and wants to stay there. That is in father's trial testimony on page 1164 of the transcript.
And do we know from child or anyone else that that was raised with father and that he was being untruthful in that testimony?
Yes, we do, because the social workers testified that child mentioned this numerous times during visits, something like 5 times. Child
It
raised.
seems like father is kind of between a rock and a hard place. The DCF social workers are saying, don't discuss the case with him. And yet if the child brings up adoption, then what is he supposed to do?
Agreed, that puts him in a hard place, but it doesn't negate the fact that he knew, he heard it. That's a separate issue, Your Honor. And it is true that DCF routinely asks parents not to discuss issues with the child, but here father simply denied that child raised this as an issue. And I think it wasn't so much of a question of
So you're
parents-
saying it's father's credibility is what you're backing.
I'm saying father's credibility is implicated, but responding to the question Your Honor directly asked, wasn't father between a rock and a hard place? This was an issue of parents' ability to listen to child, to absorb what child was saying. In fact, parents did discuss the issue of adoption with child. It's not that father simply remained mute. Both parents affirmatively responded that they were going to fight it, that they still loved him. They talked about what was going to happen when he came home. They were simply unable to hear what child was saying. Father, as my sister, Attorney Gao, stated, father did not raise the issue of not having visitation on the trial level. There were no motions filed. As we know, that visitation was paused during the pandemic, but father's remedy was to raise that issue then. That never happened. Furthermore, child was in substitute care long before the pandemic started. He went into substitute care at the age of 5, not 6. In January of 2016, he turned 6 in July of that year. He shuffled through several placements before finally landing in the pre-adoptive home in July of 2019. But the testimony that I raise sums up the 2 main themes of this case. First, the parents' persistent refusal to be truthful, leading to serious consequences negatively impacting their ability to safely parent child. And 2, their inability to meet child's needs were he to be forcibly removed from his current home. Parents' untruthfulness is detailed, is set forth in great detail throughout the record, through their own testimony, which was inconsistent. Mother gave multiple—
Does untruthfulness in response to DCF inquiries render the parent unfit?
Not alone, but what it did was mother's untruthfulness about child's parentage prevented DCF from engaging father for a year. Mother's untruthfulness about her substance use caused multiple doctors to prescribe opiates, etc.
So if parents don't welcome DCF involvement with open arms, then that contributes to a finding of unfitness.
Their failure to actively hinder DCF's involvement. Nobody's asking anyone to love the fact that DCF is involved in their life. I see my time is up, Your Honor. May I finish answering?
You certainly may.
Okay, thank you. No one expects parents to joyfully welcome DCF into their lives open arms. Of course, it is a great intrusion by the state, but where serious problems have been identified, lying and avoiding and continual evasive behavior with regards to serious issues such as continued substance abuse, continued domestic violence, continued housing instability, contributed to the very justified conclusion that these parents were unfit. It's the underlying facts coupled with parents' refusal to honestly face those issues. That, combined with child's natural bond with his pre-adoptive family and parents' inability to meet his needs should he be forcibly removed, rendered the judge's decision to terminate their rights completely justifiable on the record evidence. Thank you, Justices.
Was there a time when the parents were in compliance with their service plans and had stable housing?
Not to my recollection, Your Honor.
Any other questions from the panel? Hearing none, thank you all very much. The matter stands submitted.
Thank you.
The case is now being recorded.
Thank you. The next matter on our docket is matter 20P0934, Commonwealth versus Brian Joyce. Good morning to you both. I'm Judge Desmond, and with me is Judge Sachs and Judge D'Angelo, and we'll be the panel for this hearing. Attorney Horowitz.
May it please the court, Dan Horowitz for Mr. Brian Joyce. The Commonwealth in this case is in the position of insisting that Joyce's limited actions alone are of such a nature as that they allow inferences that he engaged in those actions in order to further a prior agreement to rob Mr. Freeman, that he shared intent with Jones. I would summarize its case as 0 + 0 is 0. Because apart from minimally suspicious circumstances regarding where Joyce parked, there is nothing that allows the fact finder to draw the necessary inferences. And I think the best way to illustrate this is following the organization of the reply, which starts with the events leading up to the robbery, and then asking if what came after changed anything. And the paucity of evidence here is going to put regularly in play the time-honored principle that where the evidence supports equally consistent, inconsistent propositions equally, that they may not be drawn, they cannot amount to sufficient evidence. So before the robbery, we basically have two bodies of evidence. We have an offer-up conversation that is an app that is used to sell goods between a Steph and Paul Freeman. Objectively speaking, it arranges the sale of a phone on the night in question. We don't know who Steph is. We don't know what device was even used. It does not move the needle either which way. The other body of evidence has to do with how Joyce parked, specifically that he chose a location that was near a light that had burnt out, and this being in the early morning hours, that meant it was even darker than the surrounding area, that he left the car running, and that as Mr. Freeman described, he was in the middle of the street. However, around page 44 of the evidence, and 43, Freeman specifies that it's still close enough to the curb that when Jones later steps out, he's stepping directly onto the curb and remaining in the door space.
Is it accurate to, that the victim, Mr. Friedman, approached the driver's side when the car first came to a stop and was directed toward the other occupant of the vehicle by your client?
He did. And I would say that's actually not even suspicious, because a person who believed that a phone purchase was about to happen would do exactly that. Similarly, they would probably not bother to parallel park. They would leave the car running because their passenger is buying a phone. The price is negotiated if they happen to know that. But at this juncture, I just want to stress that there is so much evidence missing that would allow these actions to be interpreted, like the relationship between Joyce and Jones. All the fact finder knew these were perfect strangers. There's no evidence of their relationship. There's no evidence of any conversation they had, any contacts they had before, during, or after these events. No texts, not even evidence that one is in the contact list of the other's phone.
Speaking of evidence we don't have, the Commonwealth has moved to transmit the exhibits. Do you think that they would show anything useful? And I'll ask the Commonwealth to address the same.
Yes, for example, to the extent that the speed of the car leaving the scene is at issue, these GPS records, I think it's exhibit 24, it's a minute by minute reading, and it estimates the speed of the car, average speed of the car between those each minute. But for the most part, everything is covered in the
well, they'll show that the car sped away, right?
Well, they'll show that its fastest speed during 1 minute was 46 miles per hour, that at another point it's 42, but it'll also show that most of these readings are somewhere between 15 and 30 miles per hour.
Do you dispute that it would be reasonable to infer that once the victim put his hands up, the driver, your client, would have known that there was a robbery in progress?
If he witnessed that, yes, at that moment. But about the robbery, I think what distinguishes this case from many is that the way Friedman describes it, it happens extremely quickly. Jones, the moment he shows his phone to Jones, Jones steps right out of the car onto the curb. He's still standing in what Friedman calls the door space. And as he's doing that, he raises his shirt. So Friedman puts his hands up. He just grabs the phone, says, "That's mine now," and gets back in the car. Now, it reads like this took a matter of seconds. And the question, of course, is when Joyce drives away, it's not, as the Commonwealth seems to describe it, it's not, well, does that have the objective effect of getting Jones away from the scene? It does. It's when Joyce drives away, is he acting according to a prior agreement? Or in this very narrow space in which Jones is outside the car, is there some kind of implied agreement being formed?
You think there's sufficient evidence for a conviction of accessory after the fact?
Possibly. I did not analyze that in detail, but that's the case they should have brought if they were going to bring a case. And I think this is a good time to illustrate the paucity of the evidence using Commonwealth versus Lopez. Two of them were cited in the briefing. This is the one, volume 80 of the Mass Appeals decisions. Now, this court in that case found there was not even probable cause to sustain an indictment of unarmed robbery as to the defendant named Ramos. And what had happened is Ramos left the party. He runs into defendant Lopez. Incidentally, Lopez is a contact on Ramos's cell phone list. Around this time, a call for Chinese food delivery is placed. And around this time, Ramos, Lopez, and a few other people are waiting at the top of a stairs at the delivery address. Delivery man shows up, Lopez ambushes him, knocks him down.
So there's no evidence. I mean, I think we know the case. There's no evidence that Ramos knew what Lopez had in mind before the attack. That's your point.
Right. And here we have this offer-up conversation and what the Commonwealth finds suspicious about parking in a dark area.
Let's talk about that. The victim testifies that he at least 2 times asks to go to a more lighted area and nothing is done. Isn't that a fair inference that your client who's driving the car could have moved the car to a better lighted area and deliberately didn't do so when the victim specifically asks to do so?
Well, I think the answer, he didn't, objectively, he didn't move the car. I mean, my answer is that someone who expected their passenger, who again, we don't even know if they're really known to each other in any way, expects their passenger to be buying the phone. I don't think it's much of their concern. I mean, they are likely to expect the passenger to get out, but I do not think that just failing to move the car then is sufficient to infer that there is some sort of prior agreement to rob Freeman.
Well, your client at least allegedly knows there's going to be a sale of a phone because when the victim comes to the window, there's a discussion and he says, "Go over there."
Right.
So if he's part of at least a sale and the victim says, "Hey, it's dark, can we move to somewhere light?" and your client just ignores that request, well, even if it's part of the sale, isn't there an inference that can be drawn there?
Well, in regards to, I believe Freeman was speaking to Jones. He had gone over to the passenger side and he was asking Jones, "Can you get out of the car?" Now, as to that, I meant to say—
Did he ever ask to get out of the car or did he say, "Can we move to a lighted area"?
He was asking Jones to come over to a lighted stairwell. Now, here's the thing. Jones's response was to ask to see the phone. I believe that happened 2 or 3 times. Now, again, imagining what someone who did simply expect a phone sale to happen would do, I don't think they would find it particularly surprising that the purchaser wants to at least see that there is a phone especially given the sum involved, it's around $1,000. Freeman said that he would want to see the phone before he gets out. And again, the prohibited inference here, and I think unfortunately the judge drew it, went with a gut instinct, is you can't reason backwards from the fact that an armed robbery happened to conclude that it must have been expected, it was intended, and that everything Joyce did was done to further that plan. And basic principles of joint venture include, for example, the notion that advanced knowledge plus subsequent concealment is not sufficient evidence. Presence and failing to prevent a crime, even with advanced knowledge, is not sufficient basis.
But we have ready, willing, and able to assist, right? And so here he drives them to the location. He directs them to the gentleman with the firearm. He was the 46 mile per hour highest speed. Was that immediately leaving that area?
Well, the question is, when he acts,
my question, sir, is the 46 miles per hour, was that the fastest at the moment when he left the area?
I don't recall if it's exactly the moment. It may have been, it was early on in the movement. So it very well may have been the moment he leaves.
And then the firearm was recovered in a hide in a car that was registered to a family member of the defendant. Is that correct?
Right.
So the car was equipped with a hide.
Well, the gun was secreted. I would call it the gear shift. It's housed in a sort of plastic thing. The officer called this a center console, where that plastic meets the carpet. Under there, the panel was pulled out, and the gun on Jones's side was shoved in there. But as to taking off, I do want to note that the innocent person who expected a phone purchase to happen and is surprised by this armed robbery and learns that he's armed at some point after he gets in the car, is likely to do exactly what Joyce did, because when a person finds themselves confronted by a dangerous armed man like that, they do what the armed man wants. They don't do anything to upset him. So he would take off. And if he didn't know that Jones had a gun right there, if it's still in Jones's waistband, he still at least realized something bad happened. He's got a robber in his car now, and he'd have his own self-preservation instinct. He would not want to get caught. He would not want to resist. As you mentioned, Your Honor, the car is registered to Very Joyce. We don't know the family's overall financial situation, but the judge had to know that Joyce's attorneys had been appointed. So there's this separate, even if it's lesser, financial motive not to do something like just get out of the car and flee away from Jones. In terms of being ready to assist, I'd like to use one of the Commonwealth's cases as contrast. It's Commonwealth versus Colon. There, the defendant is one of three people who approach the victim and the victim's friend. Now, before they make contact, the defendant and the would-be assailant are conferring. The assailant walks over, menaces the victim, demands a bracelet. As that's going on, the defendant then approaches the victim's friend and says, "Don't watch, don't worry about what's going on." Robbery completed, they leave together. Now, there are two examples of the kind of evidence missing. There's an actual conversation right before the crime, providing a strong basis to infer it was about what was coming. And then the defendant does what I'd call a positive action. He walks over to the victim's friend and helps him not raise an alarm, helps to stop him. Joyce just sat in the car and then drove off. And I would also say, I believe you mentioned the gun is found in the car. The phone is found in the car. Jones is in the car. Okay. This is a half hour later, if it's not the next day. And I think the reasons...
And can't an inference be raised on that alone? There's nothing to say, no evidence to suggest that Joyce tried to get away from the scene without the victim, without the co-defendant being present. They're appearingly, at least from the evidence, I don't want to say getting along, but there's no disagreement between the two. There's not like an argument. So again, from your argument that if this was a robbery that Joyce didn't know about, wouldn't there be some evidence that Joyce was upset about what had occurred as opposed to just driving his friend around? A gun is found in the car. Isn't an inference fair there?
No, not necessarily, because again, consider the speed of the robbery. Once Jones is out of the car, it's completed very quickly. Now, as I said, if the innocent person would have just been shocked by the armed robber getting back in the car, is he going to resist and argue? I don't think that is a fair inference. And in fact, as to, I believe you said earlier, why not try to escape without him? Well, as Freeman said, Jones is standing right in that door space, as he calls it. So trying to drive off, he could easily catch and drag Jones or run him over, and now he's potentially on the hook for something else. And we got to remember the human element. I mean,
right. So about the human element, one, so as I understand it, you're almost suggesting that Joyce is a victim too. Is that correct?
Yeah.
Okay.
I mean,
when they are finally stopped and the police are present and they're separated, does Joyce do anything that you would expect from a reasonable victim?
He acts calm. I believe he's described by the officer as acting calm. And when he's asked whether he has a license for a firearm, he says, I don't have a firearm.
Would a reasonable victim be calm in that situation?
Faced with police officers, early morning hours, this day and age,
They'd
try to be
involved in an armed robbery that they knew nothing about.
They'd try to be.
Would they?
Even if, Your Honor, I'd put it this way, even if that's suspicious isn't enough.
I understand.
We just don't have proof beyond a reasonable doubt here. Thank you.
It's a circumstantial case. I understand. Any other questions from the panel? Hearing none. Attorney Horwitz, I see that your time. Thank you very much, sir. Attorney Hartley.
Good morning, and may it please the court, Brooke Hartley for the Commonwealth. This court should affirm the defendant's convictions where there was sufficient evidence to convict the defendant of armed robbery as a joint venturer. And I would just point out that I think many of the defendant's arguments are coming from the light most favorable to the defendant. And when considered in the light most favorable to the Commonwealth, the evidence here was sufficient. So unless the court has specific questions, I'd like to start by just running through.
What would the exhibits show us? Would they make a difference?
I think it would be worth looking at the video. I think it gives good context for the court for how close the defendant was to the armed robbery and what he maybe could and couldn't see and what the reasonable inferences were there. I think that would be the most important thing for the court to look at.
Counsel, let's assume, based not only what we would see on the video, but the testimony, that Mr. Joyce saw everything that went on, including the co-defendant lifting his shirt up, including Joyce seeing the gun. What was Mr. Joyce supposed to do if he was just an innocent bystander, as opposing counsel suggests? What should he have done?
Your Honor, I think asking that question is, again, looking at the evidence in the light most favorable to the defendant. And I think when we look at all of the facts in totality, both what happened before, during, and after, that the evidence here was sufficient to show that he had the intent and participated in the commission of the armed robbery. And if I could start from the beginning, the defendant—
Well, hold on, before we get to that, what would you have expected him to do? That's the question from Judge D'Angelo. Can you take a shot at that question, please?
Sure, I can certainly take a shot at it, but I think it's incredibly speculative. I suppose, again, I don't think the facts, when taken in totality, would show what we have here. I'm not sure he would have parked in a dark place. He would have had his foot on the brake the entire time. His co-venturer would have left the door open and stood right there, all setting up for a quick escape to then—
How is any of that inconsistent with a sale of the phone? Or at least what Joyce might understand to be the sale of the phone?
Your Honor, I think that's a possible inference, but
why isn't it equally possible?
I don't think it's equally possible, and I think that's borne out in the case law. And if Your Honor would like, I could give some examples to show why I think this case is analogous to certain cases where the court has found that there was sufficient evidence with, and I submit, I agree, this is circumstantial. And if we had evidence that the two had communicated before the armed robbery, certainly this would be a much stronger case. But I don't think we need that based on what the case law says when we're looking at this.
Would you agree that you need to prove advanced knowledge of the weapon?
Yes, absolutely.
And at what point do you think it's reasonable to infer that the defendant knew of the weapon?
I think based on the case law, we can infer that the defendant knew about the weapon the whole time. And I think that if you look at Commonwealth v. Rakes, that's a Supreme Judicial Court case. And that case says that a jury can infer that the defendant knew that his co-venturer was armed when a victim's resistance can be reasonably anticipated.
Okay, so then the inference of a gun depends on knowledge that a robbery was going to occur.
Absolutely, yes.
Okay,
I
so
agree.
what's the evidence that that Joyce knew a robbery was going to occur?
Sure, I think, and that's where, if I may, I'd like to start from the beginning and go through the facts.
Well,
and the
start wherever you need to,
reasonable
but what is
inferences.
the evidence that Joyce knew before
Yes.
the victim stuck his hands up?
Absolutely, Your Honor. So the defendant drove, and again, in isolation, I agree that many of these facts would not be enough for sufficient evidence. But I'll start with the fact that the defendant drove Jones to the robbery in the middle of the night. They're in the car together immediately before the robbery, and they have the opportunity to plan the robbery. Certainly alone, that's not enough. We can't make the inference that they did plan the robbery, but that is one factor here.
Okay,
Next,
so all
we
three of those things aren't enough. That he drove him there, that they had the opportunity, that they were
No,
together.
I
and they
don't
had
think
the
those would be enough. I don't
Okay.
think those would be enough. He then parks in a dark area where there's a broken street light above.
But doesn't he park right where the victim is waiting on the curb?
The victim isn't outside yet, I don't believe, based on the testimony.
He pulls up right in front of the address that whoever Steph is has given him, or the
He
Jones.
certainly pulls up close to the address. It might be right in front of it. I'm not exactly sure that there's testimony that it's right in front of the address.
Okay, so where he stops is not in and of itself suspicious, is it?
I think the fact that he stopped, again, inferences in the light most favorable to the Commonwealth, that he stops under a broken street light is something that we can consider and something that the court should consider. And then you have the fact that, and the inference there is that, of course, if this was going to be an armed robbery, the defendants want to hide their identity and they want to make for an easy escape. Next, you have the fact that once the victim comes out, he leaves the car running with the foot on the brake. And that's actually something that the testimony is that he leaves the car running. But if you look at the exhibits, you can see the brake lights on also. And again, this is the inference here, is that he's not a passive bystander, that this is a getaway car.
So
Next,
let me, and again, I understand, I can almost guess what your response is going to be, but if you're the purchaser of the phone and you're going to Charlestown at 2 o'clock or 1 o'clock, what time is it again?
it's about 1 o'clock in the morning.
1 o'clock in the morning. Wouldn't it be reasonable to be concerned about you being robbed as the purchaser? So you might keep your foot on the car so you can get away quickly. You might be reluctant to go to some area away from the car where you might be feeling you're getting lured to where you could be robbed. Why is that unreasonable?
I think an equal inference there is that you would want to be able to do this in the light to protect yourself, to see the person who you're making the sale with. I think that the stronger inference that this was in the dark with his foot on the brake is that it is a getaway car. And again, I know I sound like a broken record, but light most favorable to the Commonwealth. And it does not have to be necessary or inescapable. It just has to be a reasonable possible inference. And I would also just
And a more likely inference than the opposite?
yes, absolutely.
It has to be more likely.
It does. They can't be equal inferences. That's absolutely correct. And I would just highlight the language in Commonwealth v. Kilburn, which is a Supreme Judicial Court case where the court says that inferences are determined not by hard and fast rules of law, but by experience and common sense. And again, I think when you look in totality using common sense at the facts here, the inferences is that this was not, the defendant did not think this was an innocent transaction, but rather this was a setup. And if you continue on the facts here, I think I left off at, he left the car running with his foot on the brake. The next thing that happens is he directs the victim to go to the passenger side. And again,
Equally consistent with a sale?
I think it by itself, perhaps equally consistent with a sale, but when looked at in totality, I think that the reasonable inference here is that this was a plan, that they had planned this, that he was sending him to the other side to interact with the co-venturer, because that's the person who had the gun and that's the person who was going to commit the armed robbery.
Or that's the guy that was going to buy the phone and he was just driving his friend.
Again, when looked at in isolation, yes, an equal inference.
With this one, even in a light most favorable to the Commonwealth, I guess I'm missing what the nefarious inference can be drawn, that he goes to the window of the driver and the driver goes, go talk to that guy. He's the one that's either going to buy the phone or steal the phone. I guess I'm missing the nefarious.
No, I understand, Your Honor. And I think my point is that by itself, those are equal inferences, certainly. But when you look at the fact that he drove him to a robbery in the middle of the night, he pulled up to the darkest place on the road. He kept his.
Is there evidence of that he pulled up to the darkest place on the road?
The place without the street light. I'm sorry if that was an overstatement. Of the place where the street light was broken.
But no evidence that it isn't right in front of the address.
No.
That someone told him to go to.
No, Your Honor.
Okay.
Correct. And then the fact that Jones exited the car.
And so if they were setting up the buyers for a robbery, having them pull up to the darkest place on the road would be consistent with that, right?
Sure, I think it would be consistent, but I don't think there's any direction from the buyer that says park under the broken street light. So again, I think that would be an inference in the light most favorable to the defendant. And
we don't really know where the buyer lived, do we? We just know that he told them to come to a particular address.
I think there is.
Didn't he try to deny that later on that was?
He did. He sent a message to the co-venturers saying that that's not even where he lives. But I think there was testimony that at trial that he actually did live there and he was concerned for his safety, or he lived right next door and was concerned for his safety. And then you have the actual, I think we've gotten to the actual armed robbery. But I would also just note that I think it's significant. I think it actually supports the Commonwealth's case that he leaves the door open and makes the purchase right there and that it's a quick purchase. Again, the inference is that this is a getaway car. He's ready to hop back in and they're ready to flee, which he does. After Jones shows him the handle of the gun, he says, "It's my phone now." The victim puts his hands up and he takes the phone. He then places the iPhone.
Attorney Hartley, prior to the victim putting his hands up after the co-defendant shows the gun, even by inference, what evidence is there that Joyce knew the co-defendant had a gun as opposed to just a robbery?
Sure, Your Honor. And it's circumstantial evidence. It's absolutely circumstantial evidence. There's no evidence. Again, we don't have any evidence of communication between the two of them. And if we did, it would be a much stronger case. But we don't. But I think Commonwealth v. Rake says it's reasonable to infer that resistance can be anticipated. And this is a $1,000 iPhone. I think it's borne out by the facts of this case where the victim actually chases the car down after, that it's unlikely that he was just going to part with this without some sort of a show of force. And if I could, I'd like to just turn to a couple cases that I think the defendant briefly mentioned, but that I think are analogous to this case and support the fact that the fact finder can find sufficient evidence with circumstantial evidence of what happened before, which is what we're missing in this case, direct evidence of, a plan or knowledge of the firearm. And I would start with Cannon. I think that's the Commonwealth's strongest case here. That's 449 Mass 462. So in Cannon, the defendant, excuse me, The defendant and two other men go to the victim's house around midnight to buy drugs, and the defendant was a regular customer of the victim in that case. He sort of knew his general practices about how he usually did his drug deals. So the door is propped open, as it sometimes was, door to his apartment. And one of the three men rings the bell, the other two go in quickly, and the third follows right behind.
Okay, well, that's pretty darn suspicious right there.
Sure, absolutely. But we don't know.
But the guy who's ringing the bell knows that the two who are going in ahead have some evil motive.
Again, yes.
Do we have that here?
We don't have any evidence in that case of who rang the bell or who went in. Whether the defendant was one of those two who just went in and the other guy rang the bell behind him, there's no evidence of that here. And then what happens next, I think, is very significant here. So the victim.
Well, would it matter in canon? I mean, whether you went in ahead of the guy who was ringing the bell, or if you were the guy ringing the bell and the other two guys went ahead of you, it's suspicious.
Well, there's no direct evidence that the defendant in this case either rang the bell or had knowledge that someone else was exhibiting this suspicious behavior.
You mean, so the two guys who went in ahead in canon didn't know that a third guy was waiting behind?
I'm not sure they did. And I
wasn't there something about familiarity with the fact that the victim wouldn't let people into his home unless, or wouldn't open his door unless he had admitted someone via the buzzer?
There was evidence about familiarity, but also there was evidence that he sometimes left the door propped open. So they just went right in. He didn't even have to let them in. And then once they got up there, the victim's girlfriend was in the apartment, and she recognized the defendant's voice asking the victim to buy drugs. And then after that happened, she recognized another voice, not the defendant's. She didn't recognize the voice. She heard another voice that she didn't know say, "Run him," which she understood to mean rob him. She then heard 3 gunshots. She comes out of the room to see one man running out the door and the defendant standing in the living room looking what she describes to be surprised and scared. And they look at each other for about 15 seconds, and then he flees and gets in his car. The court found that the defendant there made no effort to render aid to the victim, made no attempt to disassociate from his cohorts, and he fled the scene with his cohorts, and found that this was sufficient evidence for a fact finder to reasonably infer that the robbery had been planned jointly, and that the defendant was attempting to execute that plan. And I would say that's significant because I see my time's up. May I just finish that thought, or would the court like to end there?
You certainly may.
Thank you, Your Honor. I think that's significant because it shows that, of course, although we do have to have evidence of before, during, and after, we can also consider what happened subsequently and the defendant's subsequent role in the crime. And I think that's very important here, and it colors the circumstantial evidence that happened before and during the crime. And if the court has no further questions, I will rest on my brief.
Hearing none, the matter stands submitted. Thank you.
The case is now being recorded.
Thank you very much. Good morning. My name is Judge Desmond. With me is Judge Sachs and Judge D'Angelo will be your panel for this hearing. The matter is Commonwealth versus Jessica Bruno, 21P0748. Attorney Reardon.
Good morning, may it please the court. Deborah Reardon representing Jessica Bruno, the appellant. It's my understanding that Ms. Bruno is watching on YouTube today. The defendant's motion for required finding of not guilty should have been allowed on the breaking and entering with the intent to commit a felony count that she was convicted of.
So let me ask you this. The motion is made at the conclusion of the Commonwealth's case in chief, correct? And it's a general motion. It's a motion that encompasses all 3 indictments. Counsel waives argument and has no specific theory as to any of the indictments. Is that fair to say?
It's fair to say.
So is the motion preserved?
Yes, well, according to the Van Bell court, which is at 455 Mass 408. The court said that if all elements are not proven, the case is legally insufficient and that you can't have a conviction based on legally insufficient evidence. And it is a substantial risk of miscarriage of justice. So
Do we need to have a specific theory of liability, though, to get to that point?
no, I do not believe you do.
Okay.
But the general motion did argue that the evidence was insufficient. I understand that's as much as it says. And I wish it said more, but it doesn't. But nevertheless, there was a substantial risk of miscarriage of justice in this case.
Tell me why.
The point in time to look at is when Ms. Bruno went into Dominic Bazzi's vehicle. What was her intent at the time? Now, we can't see into her mind, but we can see her actions and we can look back at what happened before she got to that point. She came to the apartment that night to get two things of utmost importance, were her child's clothes that were being washed and her parking pass for her South End apartment building in Boston. This parking pass is something that couldn't be replaced. She couldn't go to the management and say, I lost my pass, I misplaced it, can I have another one?
Didn't she want to recover her $4,000 as well?
She did. She had made an investment with Miss Dominic Bazzi, but she did want possibly to get her money back. She expected that she would have gotten the product earlier that evening based on the text, but they would never produce at her apartment, so she had to go to Dominic Bazzi's apartment to get these things.
When she went into the car, why wasn't it a fair inference that she entered that car with the intention to steal the car?
Well, she had her own car there. Her car was parked behind this car. So there was no way for that car to, if she wanted to steal it, if you were one word to infer that she wanted to steal it, there was no way for her to drive. The car was blocked in, and Miss Bruno's car was parked behind that car in the parking lot. So
there was evidence in the transcript that the car was blocked in.
I don't know if that exact word was used, but the testimony was that Miss Bruno's car was parked behind that car. Rather, and I'm not sure if it said perpendicular or not, but knowing how these apartment buildings, the parking spaces go, it was not pulled in directly behind her. So I don't think that would be a fair inference that she wanted to steal the vehicle.
Why wouldn't it not be reasonable to infer that she wanted to steal anything and everything of maximum value that could be found within that car? All four doors were open, the trunk was open, she took a bag of stuff that presumably she didn't even know what was in the bag. She took a bag of art supplies that she presumably didn't know what the value of those things were. And I'm speaking particularly at the time of the Commonwealth's arrest and the case in chief. I think it's an easier question when we get to the totality of the evidence, but I'm talking about specifically when the Commonwealth arrest.
I think one needs to look at the text messages and the discussions that took place before that. I need my pass, I need my pass, I need my pass. Where's the pass? You didn't give me the pass. And I think that taking two bags of items without knowing what they are doesn't show an intent to steal more than $1,200 worth of items. And she also, and I know this is jumping ahead to her testimony, but Ms. Bruno testified that she was using these as negotiating tools, if you will. I'll give you your bag if you get me my parking pass and my money.
Certainly, the jury was free to not believe that, right? They didn't have to credit that testimony, did they?
That's true. That's true.
Am I right that the evidence of the $4,000 investment or loan or whatever you want to call it came in only in the defendant's case?
I believe so, yes.
Does that matter to the sufficiency analysis when we look at the motion, general motion made at the close of the Commonwealth's case?
Yes, that would not affect, that would be outside of that motion.
Well,
Because-
that's my question, and is, since it was a general motion, does it make a difference? There was no argument on armed, I'm sorry, not unarmed, on breaking and entering in the nighttime with intent to commit a felony. There was no argument about the value. There was no argument about what felony.
Excuse me. That is one way to look at it. The other way to look at it is that it didn't, there was no testimony about the money at that point. That it was owed to Ms. Bruno or it wasn't owed. So I don't believe the general motion would include that $4,000 that was owed. The second part of my argument is that there was no proof of what the value of the items in the bags was. And
Does it matter?
it does matter in that if the value wasn't greater than $1,200, it wasn't a felony, and that it was a
But
misdemeanor.
the question is what she intended to do. What she could have intended to steal over $1,200 and left with nothing. Would that change the sufficiency?
I'm sorry, I'm not sure I understand your question.
The question is, when she broke into the vehicle with the intent to commit the larceny or the felony, what if she had intended to, she thought there was going to be a lot of jewelry in there that was going to be valued at over $5,000, and then when she got in the car, there was nothing there. Would that change what she intended to do at all? I mean, don't the cases say you don't have to commit the larceny to satisfy with intent?
Cases do say that. One could infer that a person wouldn't leave anything of that great value in their car unlocked in the parking lot of their apartment complex, where they could not even see the car from their apartment. The doors were open. No doors were unlocked. You know,
Well, she left her passport in there, right? She left her
I'm sorry?
immigration papers in there.
or perhaps they didn't, one would suggest they don't have the value that is necessary, and that there was no evidence of if the immigration papers were valid, if they were still active. There was no evidence of Dominic Bassey's immigration status at trial. So those papers could have been old papers.
Did defense counsel request a lesser included offense go to the jury?
I do not believe he did.
What should we do with that?
I would suggest that you can look at this de novo, and that you could reduce it to a misdemeanor yourselves without anything further. I would prefer that you reverse the conviction for assault, of breaking and entering to commit a felony, but you de novo could review this and can review this and issue a lesser included.
Would you agree that when she entered the car, there's a fair inference that she intended to take something from that car, or else why would she have entered it at the time the Commonwealth rested?
I think it's a fair inference, but it's also a fair inference that she wanted to take what was hers.
So if it's a fair inference, and I understand your argument about why she may have, but if it's a fair inference, you would agree then there's at least enough evidence for a breaking and entering with the intent to commit a misdemeanor. So this would not be a total reversal. This would be a reversal to a lesser included if we went that direction.
Yes.
Does each opening of a door or the lid to the trunk constitute a separate break? So that do we evaluate the evidence of her intent before each time she opens a door, or again when she goes around to the trunk, or is it just her intent at the time she opened the first door?
I did not find any cases that said that one should look at each time a door is opened in a car. So I would say the initial time. And if there are no further questions, I will rest on my brief.
So we certainly can consider the hostility between the defendant and the victim that seems to escalate once she arrives at the apartment complex, correct? She's angry because she's not answering the door. She's told that to come all the way out here, and now nobody's answering the door. She goes into the apartment, almost forces her way into the apartment. They start to wrestle, and she's trying to be physically removed from the apartment by the victim in this matter. She ends up punching her in the face, and then she goes downstairs and rifles the car. We're allowed to consider all of those facts. Is that fair to say?
Those things can be considered, yes.
Any other questions from the panel?
Thank you. I'll rest on my brief.
Thank you, Attorney Reed. And Attorney McGee.
Good morning, Justices of the Appeals Court. Michael McGee for the Norfolk District Attorney's Office. May it please the court. Where after a verbal and physical altercation, the defendant broke and entered the victim's car and removed 2 bags, which included the victim's passport, immigration papers, credit cards, art supplies, and other documents, attempted to flee and then drove over the victim. In the light most favorable to the Commonwealth, at the close of the Commonwealth's evidence, there was ample evidence of felonious intent, and the judge properly denied the defendant's motion for required finding on the breaking and entering charge. It matters little or none as to the value, citing Commonwealth versus Hill. In that case, similar to this,
but she had to have the intent to take something of more than $1,200 value.
Correct. At the time of the motion for required.
Was there any evidence of that in the Commonwealth's case?
There was. At the close of the Commonwealth's case, what you had is evidence of an altercation. Someone had broken into an apartment, not broken into, but had entered an apartment building that required someone to be buzzed up, had entered an apartment, caused the altercation involving the punch to the face, fled, went into a car that resulted in the alarm going off, broke into that, and could have taken anything, could have taken the vehicle itself.
Could have, but what evidence is there that that was the intent to take something more than worth more than $1,200?
All the doors were open, the trunks were open, the trunk was open, the car was rummaged through, and the person, the defendant, took the items from the car. It was a reasonable inference in the light most favorable to the Commonwealth that had there been anything of over $1,200, the defendant would have taken it. And could have been the car radio, could have been a piece of jewelry. When the defendant entered that car, there was a reasonable inference that she would have taken something over $1,200, that intent at the time of the break, not after.
Couldn't one say that that's speculative? From the Commonwealth's case, the evidence was that she wanted her parking pass, and I think there was one other thing she wanted. Well, she got, or at least had the opportunity to get her laundry, so she wasn't looking in the car for that.
There, at the close of the Commonwealth's case, and it's my understanding that there wasn't that discussion of the easy pass. I believe that was the defendant's version of the facts, that she only went in there for looking for the easy pass, and that she saw other items and she took them as collateral for the easy pass. And that was after the general motion for required finding.
So at the close of the, sorry, go ahead.
I'm going to follow up on your question, Justice Sachs. So what evidence can you point to as to what her intent was to specifically steal from that car?
She took the items out of the car. She took the 2 bags that had all the art supplies, and she had all those things. She didn't know what was in them necessarily. She took what she could out of the car, jumped in another car, drove away, and almost ran over the victim in this case.
But if she doesn't think what's in those bags of documents is worth more than $1,200, do we have the necessary intent?
It's a reasonable inference that for a juror to have made that anything of value could be in there, and she took whatever she could. But she entered a vehicle, she broke into it. There could be any items in there, including the car itself.
Well, does one ordinarily keep items worth $1,200 in I don't know whether there's evidence of what kind of bags these were, but one was a Blick art supplies bag. You fit $1,200 worth of art supplies in one bag?
When one enters a car, breaks into a car and sets off the alarm, there's a reasonable inference that if there was a set of keys in there, they'd take the car itself.
Well, is there evidence that she drove her own car to this site? She certainly had a car, or else she wouldn't need a parking pass.
They had joint access to the vehicle. She may have taken it if she thought it was better.
But that's pretty speculative, isn't it? That she intended to take the car? If she had the keys to the car, she wouldn't have broken in. If she didn't have the keys, is there any evidence that she intended to or knew how to hotwire the car?
Had the keys been in there, where somebody broke into a vehicle after an altercation and under all these circumstances and saw the car and saw those keys, particularly under these facts, where she eventually ended up testifying that she took items for collateral, it's a reasonable inference.
Eventually, but not until her case. And I do want to ask you whether that's significant, given the general motion for required finding at the close of the Commonwealth's case.
It's significant in the fact that at the close of the Commonwealth's case, and because it was a general motion, that any alternative could have been considered by the court, and a reasonable inference could have been drawn that as she entered the car, the defendant entered the car, it could have been a valuable item in there. It could have been the car itself. It's at the time of the break and the entering of the vehicle as to the intent.
Attorney McGee, I guess what I'm having trouble following is, under your theory, anytime a defendant breaks and enters a car, there should be a fair inference that it could be over $1,200. And I'm not sure you can point to anything that says that's what the case law is.
No, what I'm suggesting, Your Honor, is that this was a general motion for required finding. There was no argument about that theory about the felony.
So if you can point to any other theory on which she intended to steal something over $1,200, you'd be okay.
Had defense counsel in this case at trial argued that the Commonwealth didn't meet their burden on the theory of intent to commit a felony and suggested that a misdemeanor could have been committed here at the time that the Commonwealth's case had rested, it would be appropriate here to make that argument that, yes, quite possibly it could have been the defendant could have been looking for snare change, and that the Commonwealth didn't prove that in their case in chief. But where there was a general motion for required finding, alternative theories could have been considered by the judge.
When you say alternative theories, does that mean alternative theories for the same crime? Or if there were, what, 3 offenses at issue here? Maybe at least 2. Then if she didn't specify which charge she was moving on, then a general motion for required finding doesn't preserve a sufficiency argument as to either of the charges?
It doesn't preserve the issue that appellate counsel raises now.
Well, I want to know what the case law says. Is it you have to have different theories for the same charge, or do you have to have just different charges in order for a general motion to be insufficient?
For the felony.
Could there have been could the government have had a theory of some other felony other than larceny?
For the larceny of a motor vehicle? I mean, that's fair. It could have been larceny of any item over to $1,200. Where this situation is that the defendant doesn't know when they enter a vehicle what they're going to find in there, and then just takes a couple of bags out of there. There's a reasonable inference in light most favorable to the Commonwealth that they have that intent to commit a felony therein, specifically larceny over $1,200. And that's a reasonable inference for a jury to, especially given the surrounding circumstances here, where somebody walked into an apartment building that they're not permitted to be in. They've assaulted the victim here already in the apartment, left, and then break into a vehicle and set off the alarms, and then flee and then run over the victim in this case. Given all those surrounding circumstances, it is not speculative to assume that if there was a piece of jewelry sitting in the glove somewhere in the vehicle, that the defendant wouldn't have taken it. Rummaged through the whole vehicle, went through the trunk, and grabbed the 2 bags as soon as she saw the victim running out of the building.
So, counsel, are you suggesting that if the defendant, at the time the Commonwealth rested, had asked for a required finding of not guilty to so much of the indictment as breaking and entering with the intent to commit a larceny over $1,200, it should have been allowed?
No.
If they made that specific request?
No, I would say if the I don't mean to be just curt and say no. Given the facts and the totality of the circumstances, that motion would have been denied based upon all of these facts that I've spoken about. That before the Commonwealth had closed their case, the jury knew and the judge knew that the defendant had committed this verbal and physical assault, had left the apartment building, removed the 2 bags, broken into the vehicle, removed 2 bags, which included passports and immigration papers, credit cards, and other documents, attempted to flee, and then ran over the victim in this case. Given that totality of circumstances, similar to that of Commonwealth versus Hill and Commonwealth versus Larzell, there was sufficient evidence to survive that motion, and it would have been properly denied, even if there was a specific request or specific argument, I should say. Unless the justices have any other questions, I would rest on my colleague's brief.
If I can just ask you one more time.
Of course.
To say what theory of intent to commit a felony, other than intent to steal other than the intent to steal something as collateral for the $4,000, you think there was sufficient evidence for at the close of the Commonwealth's case? You've talked about stealing the car. You've talked about stealing a piece of jewelry that might be in the car.
And
anything else?
The defendant did steal credit card, which certainly, and I'm trying to, off the top of my head, I couldn't recite to you which one is a felony, but did steal credit cards. And I think I would suggest to the court that, again, it's larceny, motor vehicle larceny over $1,200, could be larceny of a credit card. But really, there was certainly intent of larceny over $1,200 at the close of the Commonwealth's case. Thank you very much.
I think we get it.
The case is now being recorded.
Thank you. Good morning, counsel.
Good morning.
Your matter is the 4th matter on our docket. The docket is 2021 P1112, Commonwealth versus HALYSSON, NAVARRO. I'm Judge Desmond. With me is Judge Sachs and Judge D'Angelo will be the panel for your hearing. And Attorney O'Brien, you may begin.
Thank you, Your Honor. Your Honor, Jennifer O'Brien for the defendant, HALYSSON, NAVARRO. On appeal, we just have one. He specifically stated that it was his belief that the decision not to call Rose was because Attorney Che was nervous or knew that she would have to conduct the direct investigation. I'm sorry?
I don't think that's exactly what he said.
Well, I believe I just read it, his testimony with respect to Adriana, he wasn't as sure as why she wasn't called versus Rose. That's my understanding of what he testified to. that he believed that she was nervous and it may have impacted her decision not to call Rose, but he wasn't 100% sure that the nervousness impacted her decision not to call Almeida. With respect to Rose, Rose would have offered information that Attorney Sullivan didn't know, and that included.
What evidence is there of that? Where does he say in his affidavits or testimony that he's not aware of what Rose told Attorney Che at the interview?
He was asked at the motion for new trial hearing specific things that he was asked and didn't know. He didn't realize that that Rose and Vera had information that I believe that the victim was mad that day, that she was supposed to go to a party and she was mad at her mother because her mother didn't allow her to go to that party.
Where does he say that?
Your Honor, I don't have his, I don't have his testimony right before me. It's at my desk, but I just literally read it. There were certain things that he was aware of and that he wasn't aware of. And he wasn't aware that the mother had a new boyfriend shortly after the case and went to Brazil to have plastic surgery. There was testimony by the mother at trial that she was upset and texted her friend upstairs and told everybody to leave at the party. Rose would have testified that the party went on till about 2 or 2:30 a.m., that people were not asked to leave. There were certainly some.
Counsel, why would any of those statements, if Rose had testified, have made a difference at trial?
Well, I don't know that. I mean, it certainly would have made a difference cumulatively, because this was a situation where it was just a he said, she said case, and it was important to highlight every inconsistency. And that's what Attorney Sullivan did. That was his defense.
But what was inconsistent? I'm sorry to interrupt. What would Rose's testimony that you just referenced have made inconsistent? I guess I'm missing that.
Well, the inconsistent is that the mother was so upset that she texted upstairs a friend and made up a story about somebody being ill in Brazil, and the whole party dispersed. And Rose and Vera said that she came back upstairs and was drinking, and the party stayed till 2:30. So even after the victim in the case left, she was still drinking and partying, that she was intoxicated. That would obviously go to her perception to observe certain events, motive to lie with respect to getting a new boyfriend immediately, that the defendant had just paid for her citizenship, and as soon as that was squared away, she got a new boyfriend. I think I mean, all of those would have mattered, certainly. I think that Adriana Almeida's testimony was much more important than Rose and Vera, but Rose and Vera should have been called as well, obviously, in a case that was close like this, where every inconsistency mattered. I don't think that this court would overturn or grant the defendant a new trial just based on Rose. If that was our only argument, certainly it would have been helpful. But I think when you take Rose and Vera, and most importantly, Adriana Almeida, and factor those in, there were certainly a lot of cards that were left on the table, some of which were very important. I mean, Attorney Sullivan signed an affidavit saying that it was a grave error not to call Almeida, and that in his opinion, the defendant was deprived of a substantial defense. Obviously, that's your decision to make.
That's only once he knew of the alleged statement that the victim said she might have been dreaming or wasn't sure whether she was dreaming. But the judge found as fact that the investigator, Driscoll, never told that to Che. And so Che wasn't in a position to tell that to Sullivan. And you haven't challenged that finding as clearly erroneous.
Well, that's obviously what the judge found. I would point to the various inconsistencies. I know obviously the motion judge is in the position to determine the credibility of witnesses, and that's not, for this court. But what Attorney Che said versus what Attorney Sullivan said, there were a lot of inconsistencies about when he was in the case, who was going to do the opening or closing, what each person's role was. They were completely inconsistent. So while Judge Carlo found that particular piece to be credible as far as what Attorney Che was saying, I don't know, quite frankly, whether she made a determination about the other stuff. I don't know who she believes. It doesn't appear. You can't believe both because they're telling two different stories. Our position is, even if she wasn't told by the investigator, this was an important, crucial witness, and Attorney Che didn't speak with the witness personally.
Any case suggesting that it's unreasonable for counsel to rely on a trained investigator who was a police officer for 20 years and then had his private investigation service for another 10 years after that?
No, I don't know of a case that says that, but I think if you rely on somebody in the defense team and assuming he didn't tell her, I think that doesn't fall on the defendant. It's clear here that there was evidence that somebody on the defense team dropped the ball. So that doesn't go to the defendant because the investigator that was hired by Attorney Che didn't give him a piece of information.
So are we saying it falls on the attorney, or are we recognizing a new theory here, ineffective assistance of another member of the defense team?
Well, I think it falls upon the attorney who hires the private investigator, and he's part of the defense team. I guess the court, in asking whether justice is done, do we say, well, your PI messed this up, so too bad. It wasn't the defense team. It wasn't the defense counsel personally who did. I do think she should have spoken with this witness. I called her and I was able to get this affidavit.
Was it an unreasonable decision not to speak to Almeida, where what Driscoll had told her about Almeida's statements was consistent with what was in the police report? Detective Mercado, I think.
I think it was unreasonable not to call her, even in looking at the police report. There was another statement that she said that not just whether or not this was a dream and whether she was questioning whether it happened, but she also made the statement that the touching was done under a blanket versus over a blanket and under the pants, the pajamas, and over the pajamas.
Well, there might have been some things that Almeida would have added to the defense, but as the judge determined, there were some real risks in calling Almeida as well. She would have made the defendant out to be a liar, whether she wanted to or not, because she would have had to say that she spoke to him either that night or the following day, and certainly after that, and asked him about these allegations, when he had said that he told the police that the first time he heard of them was when the police confronted him 10 months later. So wasn't that a serious risk in calling Almeida?
Well, I think first of all, my understanding of what Almeida said is that the mother told her what the allegations were, that she wasn't a party to either the victim telling the mother what happened or to the defendant being.
But she did talk to the defendant very soon, either that night or the next day.
Thereafter, yes.
Yes. So wouldn't, if she had testified to that at trial, wouldn't that have made the defendant out to be not only a liar to the police, but a consciousness of guilt as well?
I agree. I know what you're saying, and yes, I appreciate that, and that is certainly a risk. But if you have a witness who is going to say that literally the whole thing might not have even happened, I think that weighs heavily in calling that witness.
Well, but the problem is that the judge found as fact that the attorney didn't know that. So unless we're going to recognize ineffective assistance of an investigator, I understand your position.
Yes.
It would be unfortunate if a screw up by an investigator, if it was a screw up, didn't get communicated the information he had, but that's a significant expansion of the law as it is.
Yes, I mean, with respect to whether she was touched under her pajamas or over her pajamas, the Commonwealth made a big deal of that in the opening and the closing, describing how, the defendant's hand was cold and rough, and she specifically recalled how rough and cold his hand was. So that was, I think that was an important thing to ask about. And according to—
I'm sorry. Did Attorney Sullivan highlight that for the jury?
He did not. And I asked him about that in the motion for new trial hearing. He said that he thought he did ask that during trial. If he was aware of it, he would have asked it, but he didn't ask it. So that wasn't asked either. So that was something that he probably should have known. But again, he would have asked, cross-examined about this. He would have changed his whole strategy had he known what Almeida said. I mean, that was clear in his testimony, that it's obviously a better defense not to just call an 11-year-old girl a liar when it comes to a sexual assault case, but to say, hey, her mother obviously has a reason, a motive here, but maybe the whole thing, she was asleep versus awake. I mean, if you're asleep when the whole thing happens, that is huge. And I think Attorney Sullivan agreed with that. And that's why he voluntarily signed a second affidavit after he became aware of Almeida.
So Attorney Sullivan wasn't aware of whether or not the discrepancy between whether the touching was over the pajamas or under the pajamas, or over the blanket or under the blanket?
What he said was he thought he was aware, and if he was, he would have cross-examined the witness at trial about it. But he wasn't 100% sure whether he was aware of that, but he did not cross-examine anybody at trial about that. And that's an important discrepancy, I think, just because he made such a big deal. Yes.
And Judge Carlo found that by calling that witness, it would have emphasized that the victim had reported it in that moment. Isn't that correct? And she thought that that might have been a strategic, or couldn't say it wasn't a strategic choice not to call.
Yes, and it was never disputed at trial that it wasn't reported immediately. There was a question about whether, when they went to the police, which was 10 months later, that I think defense counsel was kind of arguing that coincided with the divorce, although it was objected to and sustained as far as the divorce. I see I'm out of time.
I do have one further question.
Yes.
Regarding Rose. If she had been called, she could have testified that the mother was drunk on the night of the party when Almeida got there.
Yes.
That obviously could undercut the jury's perception of the mother's credibility or her ability to perceive, but might it also have backfired by giving a way to explain some of the discrepancies between the mother's memory of certain details and the victim's memory of certain details, while still preserving the mother's core role as a first complaint witness?
It could have, it's certainly an argument that could have been made by the Commonwealth, I'm sure.
Thank you.
Attorney O'Brien, thank you very much.
Thank you.
Attorney Staudinger.
Good morning, Your Honor, and may it please the court, Aaron Staudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. Your Honor, I believe in this case, it cannot be said that the trial counsel's decision to not call the witnesses was manifestly unreasonable and thus cannot amount to ineffective assistance of counsel. As was highlighted, the decision to call Almeida was made with an eye to the fact that Almeida's testimony would potentially expose certain facts of the defense strategy and would have served to potentially corroborate the Commonwealth's case at very little benefit, with the knowledge that that trial counsel had at the time of trial, which, as you said, this comes to this court in the posture after an evidentiary hearing on the motion for reconsideration of the motion for new trial, where a finding was made that the trial attorneys were not aware of this potential dream evidence. So approaching the decision not to call her from the context of all she would have testified to was consistent with, or what she would have testified to was consistent with her report that she had previously made to police that was available to trial counsel at the time. They thought that the benefit of calling in those inconsistencies was not worth the potential danger of corroborating the timeline, of corroborating the fact that the defendant was told of these events, but later denied it to investigators. And I think given that decision and the testimony by Attorney Che and Attorney Sullivan at the motion for reconsideration, we cannot say that that decision was manifestly unreasonable.
Putting Almeida to one side for the moment, what about the failure to call Rose, which is not something that you addressed in your brief?
Yes, and I do think the failure to call Rose likewise cannot be said to be manifestly unreasonable, as trial counsel testified to at the motion at the evidentiary hearing. He thought the trial was going well, and that calling her would have wouldn't have added anything. The basic tactic in the trial.
Did he say it wouldn't have added anything?
No, sorry, no. He said he thought the trial was going well, so they decided not to call her.
Is that enough?
I believe that is enough here, where what she would have added was simply, as was drawn out previously, what she would have added was about the mother's intoxication and the demeanor of the child prior to her going downstairs. I think introducing that evidence likewise contributes to the Commonwealth strategy. And the trial tactic was to attack the credibility of the victim and the victim's mother, and to highlight the inconsistencies that were told to the detective. That had already been accomplished. Any calling of this witness whose testimony would have been limited and would solely have been to attack the credibility of the victim's mother doesn't really add much to the defense strategy.
But was there any downside? I mean, why not try to bang away further at the mother's credibility?
I think there are potential downsides, as your honors highlighted, that the intoxication could have helped explain the memory issues and the inconsistencies by the mother. Additionally, it may have been confusing to a jury to call this witness who testifies not to seeing the event, but merely being present at a party. And I think defense counsel made a strategic decision to not further and not prolong this trial and call another witness when the credibility attacks had already been solid.
Why would it have been confusing to the jury to call Rose?
I think her potential testimony would have been very limited, and she could have only highlighted the intoxication of the mother, and the timing of the party. I think to call a witness, maybe not necessarily confusing is the word, but would not have had as much benefit as the defendant now suggests, because it would have been a very quick direct examination that would have subjected, like you said, would have exposed the possibility that there were explanations for the mother's recollection of these events. So
there's the intoxication, there's the mother's, what Rose would say was the mother's, the fact that the party didn't end. The mother said it had. And Rose also knew about the boyfriend.
Correct.
Would that have added something?
I don't believe so. I think the events occur after these events. And the fact that the mother has a new boyfriend shortly after my apologies. And the fact that the mother has a new boyfriend shortly after this incident, I don't think that adds to a bias or motivation in this event for this incident, especially since it goes to the mother and it is the victim. It is obviously the victim making the allegations, and there was likewise evidence to suggest that the victim and the defendant had a very good relationship. And then moving on to the decision. My apologies again. Moving on to the decision whether or not to call Almeida as a witness, I think, as has been addressed, given the information that trial counsel had at that time, calling her presented in Attorney Che's assessment presented a risk that was not worth taking. The inconsistencies were that Almeida would potentially highlight were already drawn out to some degree in the cross-examination of the victim and the victim's mother and the detective who conducted the interview. I also believe that much of what Almeida could have testified to was likewise subject to impeachment of her or credibility attacks on that witness, which may have detracted from the overall trial strategy. All of this to say that what Almeida could have or would have speculated to, and the value it would have had is just far too speculative to say that it would have achieved something material for the defense in this case.
What about Vera?
Vera, I believe there is the issue that Vera was unavailable at the trial, so the decision to call her may have been removed from defense counsel. But I think Vera occupies much of the same space, much of the same value as Rose does. She could only testify to the intoxication of the mother, the timing of the party, and whether the victim was happy when she was picked up by Almeida. All of that could have been covered by Rose. I think it slots into the same kind of argument that at that time, defense counsel felt that they had achieved the goals of their trial strategy in calling into the question the credibility and inconsistencies in the Commonwealth's case, and to call this other witness who would have very briefly added some additional inconsistencies was not worth it. And I don't think we can say that decision is manifestly unreasonable. Generally, the decision whether to call an additional impeachment witness or to impeach a witness is left to the discretion of the trial the trial counsel. And I don't think here we can say that Vera or Rose, the decision not to call them amounts to ineffective assistance of counsel.
Defense counsel suggests that Che shouldn't have just deferred to Vera's desire not to testify, but should have summoned her.
That is a possibility. I agree that perhaps that route could have been taken. I think you risk. She has to make the assessment in the circumstances at hand, which is that then you have somewhat of a hostile person who's been summoned or who has been brought in to the trial. Additionally, she had Rose present and believed that their testimony was substantially the same. And so I can't say, or I don't think this court can say that decision is again amounts to ineffective assistance of counsel. You risk, like I said, you risk a hostile witness when you summons them in.
Counsel, would you agree that the ineffectiveness, I guess, of the private investigator inures to the ineffectiveness of defense counsel?
I don't necessarily agree with that we impart the ineffectiveness of the investigator onto defense counsel. I think here we view it in the lens of what the defense counsel's obligation to investigate was, given the information available to them. They hired a very experienced investigator to go out and speak with this witness. They recounted the investigator recounted what occurred in that interview the next day. Defense counsel took notes of that and reviewed it with and compared it to the statements that were already made to the police investigator and decided that it was substantially the same. I think in that world, the defense counsel has no further obligation to investigate. The defense counsel cannot be held to a standard of knowing everything that they're not told, and to guess what the investigator might have asked during an interview. I think here the investigator conducted an interview and relayed that information to defense counsel, and any failings on part of the investigator should not be imparted onto the defense counsel for purposes of an ineffective assistance standard.
I guess I'm trying to follow this through for future cases, counsel. So if a defense investigator fails to ask an important question to a witness and never learns information, and thereby can't tell defense counsel about it. What are we supposed to do with something like that? There is no claim of ineffective defense investigator. It would flow to the defense counsel, wouldn't it?
And I think that is analyzed in under a bit of a reasonableness standard, in that if it was so apparent that the question should have been asked and defense counsel should have been aware that that question should have been asked, the failure to follow up on the investigator's failure to do so may be ineffective assistance to counsel. But here you don't have that situation. Here you have a situation where he's asking the witness about whether the individual is sleeping or not, and imparting that knowledge to defense counsel. Defense counsel would have no way, and it wouldn't be reasonable for defense counsel to know that there may have been testimony regarding a dream or not a dream. And I think in highlighting that, it's important to note that the witness did not bring up whether the victim said they were dreaming or not when they were interviewed by police. This information only came out when the investigator spoke to them. So while that may go to the credibility of whether that statement was made at all, or it's just something that no, he did testify to it in the motion transcript. So it would go to credibility, but I think she made the assessment that based on its failure before, that it was not unreasonable to not follow up.
Could the defendant later move for a new trial based on newly discovered evidence if the investigator knew something that was absolutely devastating to the prosecution's case, but somehow just slipped through his mind and he didn't report it to defense counsel, so counsel never knew and the defendant never knew?
I'm not sure if it would neatly fit into a theory of newly available evidence, because I guess this is somewhat of the issue that's being highlighted, is that it's information that was reasonably available to the defense counsel because the investigator had learned of it. But it may come in under a theory of newly available evidence or something to that effect. Potentially, the claim could be made, especially if there were facts that the investigator had it and withheld it, or specifically or intentionally did not convey it. But here, I just don't think that fits neatly into that, because there was evidence in and around the point he had interviewed her about the sleeping or not sleeping. And so I just don't think this would fit into a kind of newly available evidence theory.
Well, I mean, the defendant hasn't raised that point or filed that motion, so we don't have to decide it. But as we think about what could be the remedy for an investigator who learns something and doesn't convey it to defense counsel through no fault of defense counsel, I'm wondering if a motion for new trial based on newly discovered or newly available evidence is a safety valve, or whether it's just unavailable.
I think it may possibly be a safety valve, but again, that would require some assessment as to whether due diligence by defense counsel could have discovered this evidence. I think you would be looking for facts that it is specifically withheld or intentionally withheld, and there was no way that defense counsel could have known that it would be.
So here, counsel, recognizing perhaps that she's inexperienced, retained a co-counsel who's very experienced, retained a private investigator who's very experienced. The private investigator found a witness that was in New Hampshire, out-of-state witness. And Judge Carlo found that Attorney Che consulted with Attorney Sullivan throughout this trial and regarding what witnesses to call and how to proceed. Is that a fair account of where we are right now?
I believe so, Your Honor. I think I think to ultimately touch upon the issue, I think it would be unfair to say that Attorney Che was operating in isolation and Attorney Sullivan was just there for support. I think the evidence, and especially at the motion transcript, indicates that Attorney Sullivan had a pretty large role in counseling Attorney Che throughout this. And so I think certainly his experience was at play throughout this entire trial.
I see that's your time. Any additional questions from the panel? Hearing none, the matter stands submitted. Thank you both very much. Your argument.
The case is now being recorded.
Thank you. Good morning to you. Still just barely morning. This is our final matter on the docket. It is docket 2021 P0903, John Doe 526675 versus the Sex Offender Registry Board. Attorney Green.
Thank you. May it please the court. Ashley Green on behalf of Mr. Doe 526675. Mr. Doe is a 75-year-old man who's been living in the community offense-free for 2 years. As the court is aware, Mr. Doe is currently a registered level 3 offender. And the error that occurred during Mr. Doe's classification hearing is really twofold. He was not represented by adequate counsel because he did not have the opportunity to meet with or speak with his attorney before he went forward with the hearing. And the request for the continuance from his attorney was erroneously denied. The remedy that we are asking for this morning is to ensure that Mr. Doe has a chance for an individualized and fair hearing represented by adequate counsel. And we're asking that this court remand the matter back to the board, even if there is an interim classification of a level 3. So Mr. Doe has now been in the community with active dissemination for 2 years, and we realize you cannot put the toothpaste back into the tube. So we're realistic in this matter. And so the circumstances of this case are so different in that it was right at that first month that COVID hit that my client was going forward with his hearing.
Well, certainly difficult circumstances, and it would have been better if there'd been more time and more opportunity to consult. But what specific prejudice have you shown?
Sure. So the motion to continue filed by hearing counsel was very specific, satisfied all of the regulation requirements in that there were specific medical and mental health records that were required to put forth his own evidentiary hearing. And those medical records were delayed because of the COVID pandemic.
But I don't think in your brief you point to anything particular in any records that if it had been offered by the defendant at the hearing, sorry, not the defendant, Mr. Doe at the hearing, would have made a difference. And in fact, counsel at the hearing said, well, most of these things have been introduced by the board anyway.
So I do disagree in part. There's a 6-part file held at the Massachusetts Treatment Center. And at the hearing, Doe's counsel specifically pointed to the fact that the only part of that file that was introduced by the board were the treatment records, which are certainly important. But in addition to that, his medical history and medical records and mental health records, they point to a number, actually 12 different factors under the board's regulations that concern mental health and medical records.
So are any of those records now in the record before us?
But do we have them?
The record would have been closed at the hearing.
You could have moved for you could have raised an ineffective assistance claim at the Superior Court level, couldn't you? Or move to admit evidence of that for good reason wasn't presented to the board and ask for remand to the board?
Could have. Unfortunately, I did not represent Mr. Doe at the lower court, Superior Court. I only have his case on appeal where I do raise the effective assistance claim at this point. And so I do think that the remedy would be to remand at this point.
I understand, but wouldn't it be more helpful if we actually had the records so we could look at them now and say, oh, okay, had these records been offered, then maybe it would have made a difference. But we don't have any of those records, even now, today.
We don't have the records, but what we do know is that Mr. Doe was never able to meet with or speak with his attorney. And I think just that fact alone gives us enough prejudice for my client.
Was the issue of the failure to allow the motion to continue brought before the Superior Court judge?
Yes, it was.
And he what did he or she say about that? Was that discussed in the decision, or?
It was. Unfortunately, I do think that the Superior Court judge didn't realize that there was more in the record than what the board offered. And the Superior Court judge basically said, well, whatever records there were, the board offered them within their record for evidence, and so you weren't prejudiced. But the hearing counsel at the 30A hearing specifically said, there is a 6-part file. There is more. We weren't able to get to that.
Didn't the court allow for submission of some records following the hearing? He left the record open for a week for any other records?
He did. The hearing examiner did give 1 week. And on the transcript, the hearing counsel for Doe did say, I'm not going to be able to get anything in a week, which is truthful. The problem here is that the board waited too long to schedule the hearing for my client. My client was incarcerated for 3 years. Now, we know that 3 years is far too long in advance to schedule a hearing, but within the year prior to, they could have scheduled a hearing.
Well, if they'd known that the pandemic was coming, they might have done that.
They may have, but even still, it was within a month of his release that they scheduled a hearing. I've been doing this for a very long time. That is a very, very tight timeline, regardless of the pandemic. So even if we take the pandemic out of this, that 1 month to prepare and meet and plan out and get records, that is a very tight timeline. So I submit that the board erred in that way as well. But the pandemic kind of heightened the prejudice that occurred to my client, whereas he wasn't even able to meet with his attorney. Certainly with a month, he would have been able to meet with her under normal circumstances.
Well, I mean, the court did say that he was gonna, or he or she was going to give counsel some time to meet with him on the day of the hearing, which she elected not to take advantage of as well, because of, I don't know, maybe it wasn't so private that she was concerned that it may not have been a confidential conversation. And certainly, you know, a few minutes before the hearing may not have been adequate in any event, but she elected not to do that. Why didn't she move for a continuance on May 15th at the time that she'd gone out to the DOC and they told her that you're not going to have the records for a month? She knew what the hearing date was. Why did she wait till 5 days before the hearing to make the motion?
You know, that's a valid question. And unfortunately, I'm not aware of where that timeline lapse came from, because it is clear that there was, you know, a May 15th, that was a hard date. She was told at that point she wasn't gonna be able to get the medical records. There's a potential that she thought that maybe she could meet with her client between that time, but that the DOC didn't get the virtual meetings up and running in adequate time for her to meet with her client. I mean, there's a plethora of things that could have gone differently in this case. But the bottom line is the board waited too long to hold the hearing. What should have happened, I submit, is that they should have given the option to have an interim level 3 and say, we're not going to make you wait 3 years for a new hearing at the age of 74. We'll give you an interim level 3. That would have satisfied the board's concern that he would be out without dissemination, but also would have given him, his attorney, the opportunity to prepare for a hearing and have a fair hearing.
There's no provision in the board regs or the statute for an interim classification, is there?
There is not specifically, but it has happened before, and I've had cases where they've done it before, and we have taken that option.
So counsel at the board level, that is Doe's counsel, didn't ask for that.
He did not. No.
All right, so that would be another example of potential ineffective assistance, but we don't know whether there was prejudice.
Potential ineffective assistance. I submit it was ineffective assistance.
Is it possible in cases like this for appellate counsel, once counsel gets the case and sees that there's a potential ineffective assistance claim, but not clear evidence of prejudice, to seek leave from our court to file a 60B motion in the Superior Court and get more evidence into the record of prejudice?
It's my understanding there is a potential to do that. I did not take that avenue in this case. I understand the court's, position that it would be helpful to have the medical and mental health records. But if we didn't have the part of this case where Doe didn't even get to meet with his attorney prior to, I submit that on its face is enough for this case to be remanded back so that he can be adequately represented by counsel, regardless of the medical records.
Counsel, as you know, we always have to look at future cases. Are you saying that that in and of itself, regardless of whether there's prejudice shown, is an automatic ineffective assistance claim that should be allowed because counsel did not meet with their client?
Yes.
Automatically.
Yes, especially CPCS standards are very clear. When we are appointed, we are to meet with our client within 10 days. So that is on its face ineffective assistance of counsel.
That's certainly,
the pandemic is a key piece of that though, right? I mean, even if she wanted to meet with him, she didn't have the ability to meet with him. Is that fair to say?
That is absolutely accurate.
Okay. And when she was told that they wouldn't going to get the records in time, didn't they offer her an opportunity to come in and review the records so that she would have been able to see what was in the records and then maybe made a stronger motion?
They told her that, yes, that she could go in and view the records. Unfortunately, affidavits from attorneys have not been taken as a substitute for medical records. So even if she went in and saw, they told her she would not be able to have the copies made that would be required to submit to the board. So she could have written an affidavit saying, I saw X, Y, and Z, but typically the board will not accept that as a substitute.
it would be at least a way to make a record, though, to offer the affidavit that says, I looked at the medical records at the treatment center and here's what they said. I couldn't make a copy of them, but look at these important facts that I couldn't submit to the board.
Yes, it would have been helpful to have that in the record. But what the attorney for Doe did do was she took Doe's personal statement laying out all of his medical issues, and she did put that in the record.
Yeah, right.
That was dismissed by the hearing examiner because there was no medical records to back it up.
Was there anything in there that would have made a significant difference to the classification?
I think so.
I read the letter from Doe. It didn't seem to add much to what was already known.
Well, I think that the medications that he was taking for the certain diseases or illnesses that he was suffering from could have been affected. It would have gone to a motion for funds for expert witness. And so it all kind of snowballs. You know, if you don't have that one piece, his entire case is kind of thrown off, because I do submit that typically with somebody with debilitating diseases and at the age of 74 years old, an expert many times is very useful in those cases. And unfortunately, in this case, we didn't have that opportunity.
So you mentioned the CPCS standards. Assuming for purposes of argument that those correspond to the constitutional minima for performance of counsel, the standards don't address what is prejudice. And, you know, we need to find, in order to find ineffective assistance, we've got to find substandard performance and resulting prejudice.
In here, the resulting
failure to meet with a client within 10 days might very well, you know, it might constitute defective performance, but that's not enough.
And the prejudice in this case would, you know, be the other substantial ground for defense, which would be arguably the motion for funds, that he could show that he is at such an advanced stage of an illness that he is no longer able to ambulate easily. I mean, the speculation can go on and on of what he would have been able to show. He's not a healthy 35-year-old guy. And so the outcome would have been different, arguably, had he had that opportunity to have an expert. And if there were mental health issues, obviously an expert would be very helpful to the hearing examiner, as those are issues that go beyond the common knowledge and could affect directly his risk to reoffend and degree of danger to society. But without all of that evidence, he was unable to have, you know, an individualized hearing. basically they looked at the police reports and they stamped him with a level 3, which I can understand the board's concern, but at the same time, this could have been handled differently. And so that's why we're asking for it to be remanded. And as I said, if the court is concerned, and I understand with the board's position that public safety should be of the utmost importance in this case, then my client, who has already been registered as a level 3, may continue in the interim of having his new hearing, but at least he won't have to wait until 2024. And so if there are no further—
You point to Doe's age as kind of a big factor here, but wasn't the offenses occurred between when he was 58 to 67?
The offenses did occur later in life. I don't have the medical records, but I do know from his letter that his illnesses have advanced significantly throughout his incarcerated period. There are no further questions. I would rest on my brief. Thank you.
Hearing none. Attorney Chanel, thank you.
Thank you. If it pleases the court, David Chennai for the board. I think that judging from your questioning, the board's position is that prejudice hasn't been shown by the representation by the hearing counsel in this matter. And I think what really underlies that is the fact that we don't know what records theoretically existed that would have somehow lowered this individual's classification. I'm not aware of any. The counsel was given every opportunity to produce them and could have produced them even to the Superior Court and did not do so. So we're not even sure that there were additional records that were produced that were saved for what was produced by the board at the hearing. And that's essentially the board's position on this matter. So, unless there's any questions, I'd be more than happy to rest on my brief on this issue.
Hearing none, the matter stands submitted.
Thank you, Your Honor.